understand the classification of contracts, different contracts. So before we study this, we need to know that there are the main heads of the classification, and then there are going to be subheads. For example, we'll start with this classification. Main classification is the classification according to enforceability. This is the main head. Then under this classification, we have these types, these 5 types. Then we will have another main classification, which is according to the formation. This is the main head, and these 3 are parts of this main head. And then we are going to have our another head, which will be known as according to performance, and then according to number of parties involved. So there are some main headings, and then there are subheadings in each main heading. So let's start with this according to enforceability. Now, what is the enforceability, and how do we classify the contracts within this enforceability? Enforceability is that if a contract is enforceable by law or by the court. For example, if you're going to take a contract and you're going to claim that the other party did not fulfill its promises, and you want the court to resolve your matter, the court is first going to look at the enforceability part, that if your contract is enforceable by law or it is not enforceable by law. So as we've already studied the essentials of a valid contract, so the only contract which is going to be straightforwardly enforceable by law will be a valid contract. That is its first kind. Then we have the void contract. Then we have the voidable contract, unenforceable contract, illegal agreements. So all these are the classification based on enforceability. Now let's start with the first one. A valid contract, as we already know, that if it fulfills all of its essentials, it is a valid contract, which means that it has no flaw, it is completely fine, and it fulfills all of its essentials, starting from the offer and acceptance, free consent, genuine consent, capacity of parties, legal formalities. If it meets all of its requirements, it is a valid contract, and it will be enforceable by law without any hesitation by the court. This is the first type. The second type is the void contract. Now this is a little tricky to understand. Void contract is a contract which ceases to be enforceable by law, which means that at some point, this means that a void contract is not void from the beginning. It was a valid contract in the beginning, but because of certain reasons, it became void. So it is a valid contract because of certain reasons. When it becomes void, it is no more enforceable by law. Then we call it a void agreement or a void contract. Now, how is this possible? For example, if you look at this first example, A agrees to sell his house to B in 5 days. Now, two parties, they have a contract that person A is going to sell his house to B in 5 days. There are still 5 days for the execution of this contract. But the house is burnt on the third day. The third day the house is burned. That means now A cannot fulfill its promise as it was promised in the contract. Therefore, it will become impossible for A to fulfill its contractual promises. So this way, the contract, which was a legal contract, which was a valid contract, which was enforceable by law, initially, it became unenforceable by law, or it became a void contract because of this impossibility of performance. The same way, if you get a letter from a university, for example, which says that you will have to pay your fee by 23rd October 2020. If you do that, you will get the admission. For example, if you can't do it, this means that the contract will be considered as void contract. It will be valid till 23rd October 2020, but after that it will become a void contract. So this means it was a valid contract at one point, but now because of certain reasons it became void. Valid and void. The third type is the voidable contract. Now this is again more trickier to understand, but not very difficult. Now, what's the definition? If a contract is enforceable by law, the option of one party, but not on the other party, then it will be known as a voidable contract, which means, for example, a contract was done based on coercion or undue influence, that somebody pointed a gun towards one party and the two parties entered into a contract. Now, when that contract is going to go to the court, for example, the coercion happened with person A. Person A was not having free consent or a genuine consent, but somehow the agreement took place and it involves A and B. In our case, A is the victim. A doesn't have a free or a genuine consent. So this kind of contract, when it is going to go to the court is going to ask person A that if he or she wants, he or she can declare the contract as a valid contract, or this person A has the capacity to make it voidable. So if a contract is enforceable by law at the option of one party, but not on the option of other party, it is known as a voidable contract. For example, A sells his car to B under undue influence, maybe because of his father or mother or some relative or somebody, but the contract is done. Now, B has the option to void the contract or not. Now, B has the option to continue with the contract, or B also has this option that he can cancel the contract. Then we have this other example. A painter agrees to paint a house of a person A. Painter and A, they have made a spoken contract, for example. The person A afterwards prevents the painter to paint. The contract is voidable at the option of the painter. Now, if the painter wants, he can have this contract as a valid contract, or if he wants, he can have this contract as the a void contract. So these are known as voidable contracts, which are enforceable by law at the option of one party. Another type is unenforceable contract. This happens because of some technical issue or technical fault in the contract. For example, there was a contract which was written on a piece of paper or which was written on a stamp paper. Somehow that stamp paper is left in your pocket, and your clothes are washed. Now there's no ink, the terms and conditions are all erased, and there are no signs and there are no thumb impressions. So this way it has some technical fault because the court cannot read the terms and conditions and the signatures and the thumb impressions. That is why now it becomes an unenforceable contract and it cannot be enforced by law. Another example can be that a contract was required to be done on 100 rupees stamp paper, but it was done on a 10 rupees stamp paper. We'll talk about this at some other time, that how do we calculate how much amount of stamp paper do we need to write. But if this mistake was done, the contract will become unenforceable. It will not be enforced by the law. So, because of some technical fault, if the contract is not enforceable by law, it becomes an unenforceable contract. Then the last is the illegal agreement. Now, we make some contracts in which the agreement is illegal. For example, they are forbidden by your country's law. So they will become illegal agreements. Now, A gives money to B for the business of smuggled goods and share profit. Sharing profit is fine. You do that in partnership and other businesses. But doing a business of smuggled goods is forbidden by law. So this makes this whole contract as an illegal agreement. So these were the types of the contracts based on enforceability. Now the second type, the main type, is according to the formation, that how do you form a contract, in which we have these three categories: express contracts, implied contracts, quasi contracts. As you can very clearly see with the words, for example, express contract. Express contract means that a contract in which the terms and conditions of the agreement are fully and explicitly stated orally or in writing. For example, when you were making a contract, both the parties made the terms and conditions very, very clear to each other in a written form or verbally. The details were discussed, the questions were asked, and all the clarity was given to each other. So if you do a contract in which you are being very clear to each other, you are telling the terms and conditions in writing or orally to the other person, and the other person is also telling you the terms and conditions, in terms of formation, it will be known as an express contract. Then implied contract. Implied contract is formed in a whole or in parts by a conduct, as opposed to the words. Now you don't say things, you don't write things, but your conducts are the reasons which are making you and the other person feel that you are entering into a contract. For example, if you went to a restaurant and you order a cup of tea, or you have a cup of tea, it is an implied contract that you are going to pay the amount of cup of tea to the restaurant people. Now, when you go to a restaurant, you don't ask them and you don't tell them that you will be paying them the amount of money against the food that you're going to eat. And the same way, they don't ask you if you have some money before ordering the food. It is understood that both the parties will go according to the terms and conditions, and as human beings, we are actually growing with these implied contracts. It doesn't have any expression or any words or anything in written form, but you're very clear about it that you have to pay the amount of money in a restaurant. The third type is even more, you can say, complicated or something. Quasi contracts, implied in law. Now, some people call it moral obligations, but they are actually legal obligations. For example, a fictional contract imposed on parties by the court in the interest of fairness and justice, typically to prevent unjust enrichment of one party at the expense of the other party. Now, read this example. It has some flaw, but just to make it clear, if A found gold of B, it is not B's responsibility. I did it deliberately. It is A's responsibility to give back gold to B. The same way, if B leaves the goods at A's home by mistake, A uses the goods without the permission of B. Now A is bound to give B the payment of goods or the usage. Usually we talk about this phrase of finder's keeper. That is not true. If you found something, it is your legal responsibility to give it back to the person to whom it belongs. So these are known as quasi contracts. Then there is another classification based on number of parties and based on the performance. Now, performance means fulfilling a promise made in the contract. For example, one supplier agreed that he is going to deliver 100 air conditioners to the retailer. The retailer agreed that he is going to give the supplier, say, 100,000 rupees. Now, supplying the air conditioner is performance expected from the supplier. Giving 100,000 rupees to the supplier is the expected performance from the retailer. Now, in this condition, we have two types: executed contracts and executory contracts. Executed means that all fully performed by all parties. If it is fully performed by all parties, it will be known as the executed contract, which means that both the parties have fulfilled the promises they made to each other. Executed. For example, 100 air conditioners are supplied to the retailer, 100,000 rupees is given to the supplier. If both have done everything which was promised in the contract, it will be known as executed contract. But suppose if partially or fully by one or both the parties, partially and fully by one or both the parties, if performance is left, it is not yet fully performed, it will be known as the executory contract. It will be known as the executory contract. So executed and executory. Then we have this last type, which is known as unilateral versus bilateral. Uni means one, bi means two. So we already know that in a contract we must have two parties. But what happens sometimes is that in bilateral contract, both the parties are known, but in unilateral contract, one party is known, the other party is not known. For example, if I make a promise with person XYZ and we talk about terms and conditions and everything, I am also known, the XYZ person is also known. So both are known at the time of the contract. At the time of the contract. But sometimes if both are known, then it is bilateral. But sometimes there is a condition when one party is known but the other party is not known. For example, A promised to pay 1,000 to anyone who finds his or her bag. Now, in this case, one party is known, which is A, but the other party is not known at the time of the contract. Other party is who? Who can be this party? Whoever is going to find the bag. This is how we classify our contracts based on number of parties involved. Sometimes two parties are involved, sometimes one party. Two parties are involved, but sometimes two parties are known at the time of the contract.